person has been physically removed in the United States and they actually want to come back, because most of the people who have been physically removed from the United States have family member here and they want to come back. Let's say the person has a child who actually turned 21 and the child has petitioned for them and the petition I-130 has been granted. Can that person come back? Okay, the person can come back and they have to follow those 3 steps depending on where they stand currently as far as their removal order is concerned. So the first thing to figure out is to find out, first of all, how many years this person has been banned from entering the United States. Some people get banned for 5 years, some people for 10 years, some people for 20 years, and some people get banned permanently. So once you figure out what type of ban, how many years have been banned from entering the United States, then you go to the second step, is to find out whether or not you have spent those time outside of the United States, that amount of time. Let's say the person was banned for 5 years but only spent 2 years outside of the United States, and now the person is ready based on the child petition being approved. So that specific person has to actually seek permission to reapply, okay, for an immigrant visa at the consulate where they are in their country. So they're going to file the form 212, permission to reapply with USCIS. On top of it, they have to find out too whether or not they have any other grounds of inadmissibility attached to that order of removal. For example, some people get deported or they are removed physically from the United States based on crimes. So they have to find out whether that crime is waivable. Once they find out that the crime is waivable, then they have to apply concurrently using the form I-212 and the form I-601 concurrently with USCIS. Once that one is granted, that's when they are going to seek the visa at the consulate. And let's say, for example, that's the third step for people who are not in that second category, or the people who are not going to use that particular category. Those are the people who, let's say, they were removed, then something else happened after the fact. So let's say there was a mistake and they want to reopen their case, or maybe new information that they were not available at the time of trial and became available now, and they want to reopen their case based on those new information, because those information is going to change, okay, the outcome of the case. Then that's when we get into the territory of post-departure motion. Very difficult one, because you have to first of all convince the court on jurisdiction, whether or not the court has jurisdiction over the person who already left the country, right? Once we get jurisdiction, the court is convinced, then the case is reopened, then we argue. In the meantime, we're trying to figure out whether we're going to argue with that person. We're going to argue when the person is still outside remotely, or we're going to facilitate the return of that person in the United States in order for them to be able to present themselves before the court and argue the case. That's a very difficult part. But, you know, it is what it is. So the answer is yes, it depends. You can come back, but there are steps to follow in order to come back. But let's say, for example, you already use, you already stay for that period of time that the ban requires you to stay. For example, you were banned from entering the United States for 5 years and you stay for the entire time outside 5 years. Then you don't need to seek permission to reapply. You just have to find out whether or not you are inadmissible on other grounds. Once you figure that one out, then you file the waiver. Once it's granted, then you seek your visa from the consulate, okay? So this is a very difficult topic. If you need a consultation with me, you can schedule it by using the consultation link in the description box below. As a matter of fact, You need counsel for this type of procedure because you cannot do it on your own. You need guidance. If you do not have any guidance, you can contact us, okay, by scheduling your consultation using the link in the description box below. Until next time, bye bye.